Thank you, Chairnet, and welcome everyone. We would like to thank you for joining us in our webinar today to celebrate Olmstead, which means that the unnecessary segregation of people with disabilities is a form of lawful discrimination under the Americans with Disabilities Act. We'd like to welcome our partners today at the National Disability Rights Network, who will share the findings of the report, The National Landscape of Subminimum Wage, Implications and Recommendations to Elevate Competitive Integrated Employment Outcomes for Individuals with Disabilities. After we hear from our partners at the NDRN, we will open it up for a rich question and answer session. So please bring those questions. Next slide, please. I'd like to introduce our expert speakers today. But before I do that, I'd like to provide a brief physical description of myself. I am a middle-aged Latinx woman. Today I am wearing a white long sleeve button-down shirt with my hair pulled back and some round dark purple glasses. I am joining you from my home office, in which you will see a betta fish tank in the background and some flowers. Now let's move on to speaker introductions. Marlene Sayo is the Executive Director of the National Disability Rights Network. Dan Stewart is the Managing Attorney for Education and Employment at the NDRN as well. And our final speaker today is Cheryl Bates Harris, Senior Disability Advocacy Specialist. Next slide, please. And with that, we will turn it over to our partners at the NDRN, who will help us take a deeper dive into this report, in addition to sharing strategies and recommendations to elevating competitive integrated employment outcomes for people with disabilities. NDRN, take it away.
Good afternoon, everyone. As indicated, I am the Executive Director of the National Disability Rights Network, otherwise known as NDRN. I am honored to be here with you today. I am a Latina with salt and pepper shoulder-length hair. I am wearing a taupe-colored dress with an olive green sweater, and I am joining you today from Phoenix, Arizona, as I visit the P&A out here. As a bit of a background, NDRN is a nonprofit membership organization for the federally mandated P&As, otherwise known as the Protection and Advocacy Agencies. We are also the membership organization for the Client Assistance Programs, known as CAP, for individuals with disabilities. As the National Membership Association, we have aggressively sought federal support for advocacy on behalf of people with disabilities. Our initial focus in the 70s was on the institutional care of people with disabilities, especially those with intellectual disabilities that were in facilities. We have expanded our services to now also include advocacy services for all people with disabilities, no matter the type or nature of their disability. Most importantly, we're the only legally based advocacy organization established by Congress to protect the rights of all individuals with disabilities. As part of that mandate, our network includes agencies in every state and U.S. territory working to provide legal protection and advocacy services for people with disabilities. Our P&As and CAPs work to improve the lives of people with disabilities by guarding against abuse, advocating for basic rights, and ensuring access and accountability in many areas, including voting, healthcare, and employment, to name just a few. NDRN's long interest in protecting and advocating for the civil and human rights of workers with disabilities in the employment context aligns perfectly with the work that DETAC conducts on a regular basis. As we all know, the 14C program, while having original good intentions, no longer serves those intentions and has been highly problematic in implementation. We recognize that many employers are advancing competitive integrated employment, but there are still tens of thousands of workers that may benefit from more than sub-minimum wages. And so we are here today to present to you the report, and I will now pass it over to NDRN staff.
Thank you so much, Marlena. I'm Dan Stewart. I'm a managing attorney at the National Disability Rights Network. I use he, him pronouns, and today I'm wearing a brown sport coat with a multicolored tie and an aquamarine shirt, which hopefully matches the whole deal. I have a short brown hair, and I'm very honored to be here today with my colleagues Marlena and Cheryl, but I also wanted to say thank you so much to Amy and Sharnit, as well as the ASL interpreters to make this presentation such a great opportunity for us to share this amazing report. We've spent lots of time on it, and we all know that this has been an important issue, as Marlena has described, to the National Disability Rights Networks, to advocates, to families, to DETAC, to many others in the disability advocate, disability justice, disability rights field. So thank you to all for this opportunity, and we will go to the next slide, please. So what we'll do first is to give a little bit of an overview. We'll talk about the history related to 14C, modern developments, state actions, federal actions, next steps, strategies, recommendations, as well as concluding thoughts. But I wanted to begin with a little bit of an explanation of some of the terms that we will be using. As you might imagine, that this area has lots of nuanced and specific terms. And since that we all have been working in this area on this issue for quite a long time, we slip into different words and terminology that we use interchangeably. So for example, when we're talking about subminimum wages, this is a program authorized under federal law, and I will talk about that. And the name of that program in legal terms is 14C. So I will often switch between 14C wages, 14C program, subminimum wages, and sometimes special minimum wages. Special minimum wage is the term that's used in the legislation. Similarly, I'll likely go between terms such as segregated workshop, sheltered workshop, center-based employment, facility-based employment, 14C settings, community rehab programs. And I want to acknowledge that usually this term is meant as a segregated location where people with disabilities work. But I also want to acknowledge that there are many variations as time has evolved. So for example, not all community rehab programs, or CRPs, only have sheltered workshops. Indeed, they might have no sheltered workshops, and some of them are indeed leaders on competitive integrated employment, or CIE, that's competitive integrated employment. Some of these CRPs do have segregated workshops, but they also have maybe an integrated workshop next door or part of the same facility. And some have opportunities for people with disabilities, workers with disabilities, to work in the community. And some are funded in all sorts of different ways, some with government funds, some with Medicaid funds, some with state funds. There's a lot of different variety out there. So we want to acknowledge that there is a lot of variety, and that creates a little bit of confusion, but also it is the reality on how different options for people with disabilities have evolved. Okay, let's go to the next slide, please. Going into the history, really what we're talking about here on this first point is the legal origins of the 14C program, and that began in the 1930s as a part of the New Deal. And I wanted to point that out because, as we know, the New Deal was really designed to develop social programs and to advance economic opportunities, as well as jumpstart the economy in the US. And the idea, or one of the ideas behind these subminimum wage programs in the 1930s, and it's a part of the New Deal, is to shelter and protect individuals with disabilities so that they could have a clear and defined opportunity to work and to contribute to the nation's economy. I also want to point out that the idea of sheltered workshops existed before these laws in the 1930s. And indeed, as early as 1940, in the Perkins Institute for the Blind in Massachusetts, that institution, Perkins, had a sheltered workshop for individuals who were blind. So this is not obviously a new idea, but it has evolved over time and it has long and deep origins. For the actual workings and the mechanics of the 14C program, we thought we would give a very short overview. First of all, employers that wish to pay subminimum wage to workers with disabilities first need to have a certificate from the U.S. Department of Labor. And this is the authorization to provide a subminimum or a special wage. And those programs, once they receive that certificate, cannot pay that wage to anyone. That wage needs to be paid to a person with a disability. And there are definitions, of course, because lawyers are involved and laws involved for those types of definitions. But the idea here for the purposes of the presentation is that you need to have an individual with a disability for that type of work. Also, the employer needs to establish what's called a commensurate wage. And there are some complex calculations around this, but the employer determines prevailing wage for that particular job, for instance, recycling or repair of different devices or organization of materials into different shapes and forms. And then the employer also needs to determine the productivity of a particular worker. And of course, the employer needs to comply with other laws. I will put in the chat a little bit more details about subminimum wage. So if you want to get into the mechanics, check out the subminimum wage site at the U.S. Department of Labor that I've put in the chat, and you can look at all sorts of different aspects of the subminimum wage application process, as well as details on how the program works, federal guidance, and any number of things. We also wanted to point out that there's some variation in who uses these certificates. For example, there are 4 main types of employers that use these types of certificates. The largest one by far are the community rehab programs, or CRPs. 90 to 95% of the subminimum wages are granted to these CRPs. There are also subminimum wage opportunities for school to work experience programs, hospital patient worker programs, and business establishments. I've been doing this work for over a decade, and I do remember looking at some of the information from the U.S. Department of Labor and seeing many school to work employment programs using 14C certificates. Now there are less than a dozen. Similarly, there are many business enterprise that used 14C certificates, and those are also about a dozen. And again, the main user of these 14C certificates are the community rehab programs. And that's just one of the changes in the program, the 14C program, over time. Between 1940 and 2000, for example, there have been pushes to abolish subminimum wage, to adapt it, to ensure that people with disabilities received at least 50% of the minimum wage, or 75% of the minimum wage. And there has been a number of different critiques, and I'll give Cheryl a chance to jump in here with some of those critiques, but I will give one more while she gets onto camera and off of mute. And that one of the main critiques is a determination of whether a program such as 14C helps people with disability or hurts them. And I want to flag this because as we talk over time, you'll see the tension between having that protected, sheltered place for people with disabilities so that they can develop, flourish, maybe operate without stigma, and another competing, perhaps competing trend of people with disabilities being integrated into society and into work, into school, into all the community. I'll turn it over to Cheryl with a couple of ideas for critiques.
Thank you, Dan. My name is Cheryl Bates Harris, and I am a white female, aging white female with shoulder length hair, working from my home office, also with a blurred background. And I just wanted to add something to what Dan had said about the origins of 14C. This was all occurring at the end of the Depression and at a time when where men were coming back from the war wounded. So the original impetus behind this subminimum wage was to give wounded veterans returning from war the dignity of continuing to work during a time that we were a manufacturing economy. And certainly things have changed since then. So we are no longer a manufacturing economy. And the logic behind this, this piece of legislation kind of defies modern thinking. There is a lot of tension between whether or not people with disabilities are really capable of work versus do we need to protect them and just give them things to do during the day. So we could probably debate this for days and for hours. But I think one of the points that I wanted to make about who uses this program, community rehab programs take in contract work from major businesses that provides the work that is done in these sheltered workshops. And the point that I think is often missed and forgotten is the fact that these are big businesses making thousands of dollars on the backs of people with disabilities by paying them subminimum wage. So Dan, I'll turn it back over to you.
Thanks, Cheryl, for those important perspectives. The last thing on this slide is Olmstead, and I put that in italics because it's a court system, and because I'm a lawyer, we like to italicize court names. But I also have an explanation point there because it is one of the major turning points, and indeed that's why we call it Celebrating Olmstead, Recognizing Olmstead. And the reason why we want to highlight this case is because it's one of those defining moments in our nation's history that really establish a legal, and if not legal, a social imperative for integration. I like to remind people that Olmstead wasn't just a decision, it impacted real people. The two plaintiffs in that case were Lois Curtis and Elaine Wilson. They were in Georgia, and they were basically bouncing back and forth between a hospital setting and a community setting. Both of these individuals had mental health issues and intellectual disabilities, but they were able to live and function in the community. And what they needed were reasonable accommodations and supports so they could function in society and get jobs. But what was happening in Georgia at that time, this was a 1999 case, was that the state of Georgia did not have programs or supports or services that allowed Lois and Elaine to participate fully in a community setting, and instead they kept on being institutionalized. The US Supreme Court in 1999, in looking at the Americans with Disabilities Act, really focused on the integration mandate. So when you think about Olmstead, think about integration. And that has set the tone over the number of years to have a preference in a legal imperative for people with disabilities to be integrated in community settings, including employment. I just put in the chat a link to a website that has a lot of information about the Olmstead decision, some analysis of it, as well as a link to the decision. And then also just to show how much of importance this decision is, I'm also including a link in the chat from the US Department of Justice. And what is included in that link is how Olmstead has been, the Olmstead theory about integration and the legal imperative has been applied to many, many different social and community-based settings, including employment. And so if you're looking for a good resource on how much Olmstead has impacted the lives of people with disabilities, this is a great starting point. And let's go to the next slide, please. I mentioned the ADA, I mentioned Olmstead. I also wanted to mention a few other legal developments in the more recent era. And when we go back to 2001, we note VR changes, and VR stands for vocational rehab. In 2001, there was a law that changed whether or not segregated work could be counted towards employment outcomes when VR does its work. And this language said that no, you cannot. Vocational rehab cannot include a segregated work setting as a valid employment outcome. And that was a huge change because many VR agencies across the US and the territories put people with disabilities in a segregated workshop and called it good and called it a good employment outcome. 2001 came along and said that that was no longer appropriate, recognizing what happened in Olmstead and recognizing the imperative for integration and the integration mandate. In 2014, the Center for Medicaid and Medicare Services, or CMS, had a rule that's called the HCBS, or Home and Community-Based Settings Rule, that focused on making sure that Medicaid funds should not be used for services in segregated settings. As applied to employment, again, some of these CRPs are not able to use Medicaid funds to support a segregated workshop. And of course, many of you know about WIOA, or the Work Incentives Opportunity Act of 2014. And that included a whole host of provisions across the helping people get employment system, not just for people with disabilities, but also for people without disabilities. And in particular for people with disabilities, there are provisions about supported employment to develop and foster competitive integrated employment, or CIE, has funding limitations for segregated work settings, has special provisions on youth and limits on how long a youth can be provided services in a segregated setting, as well as career counseling for people to know about ways to get out of segregated workshops and to retain health insurance and other types of service benefits. I'll turn it over to Cheryl for another example.
Okay, and another piece of this these legal developments and laws that are kind of contributing and encouraging people to go to work also includes the Ticket to Work and Work Incentives Improvement Act, which passed in 1999. And the importance of that was it made some very significant changes to the work incentives, and more importantly, to the way wages are counted, and also what would happen if someone lost their benefits. Because for too long, people have relied very heavily on those Social Security benefits as a safety net and as a means of expenses. And although that may work well for a lot of people, for individuals who are on supplemental security income, or SSI, they are living at 30% below the poverty rate. So the intent of the law was, again, to fulfill the promise of the ADA that people had full inclusion into the economics of society and also allow them to work their way out of poverty. So I think that's also important to remember, that all of these different segments are kind of working together to form a support that will encourage people to, excuse me for stealing from the Marines, be all that they can be, and provide them opportunities to really show their talent and obtain jobs. Back to you, Dan.
Thanks, Cheryl. And I hope that one thing that's becoming more and more clear in this presentation is that we're, again, moving as a society and from a legal perspective to more of protecting, sheltering people with disabilities, to more of an approach for integration. And I'll have a few concluding words about that, but right now, in this juncture of time and in the last 20, 30 years, those were kind of competing, that it's either more of a segregated or sheltered place, or the other option is integrated. And I think there are some ways to reconcile them, but I just wanted to point out that that is a driving theme in what we're doing here when we're talking about subminimum wages, because many, not all, subminimum wages providers provide those employment services in segregated settings. And we want to make sure that we're thinking about honoring people's civil rights, people's human rights, as well as the legal mandates towards integration. I also wanted to point out with WIOA is that had some pretty clear definitions and restrictions for pre-employment transition services for youth. And one of these things about pre-ETS, P-R-E-E-T-S, is to ensure that youth with disabilities who are still in school have different options to approach, understand, explore competitive integrated employment. And indeed, WIOA has a focus on these services so much that there's a legal requirement that 15% of VR budget is for those pre-ET services. Let's go to the next slide, please. And turning to some of the more recent research or reviews, I just want to highlight there are, of course, more than the Government Accounting Office, or GAO. We wanted to point out that there's been a lot of study on these topics related to 14Cs. The Government Accountability Office is in the federal government. It's nonpartisan, and they are asked to look at topics on the request of our Congress people, and they do an amazing job at looking into a lot of the main questions surrounding the different programs that they're looking at. So, for example, GAO has taken 4 detailed looks at the 14C program, beginning in 1981. In 1981, there was a report that's called Stronger Federal Efforts Needed for Providing Employment Opportunities and Enforcing Labor Standards. And I'll just put a link into the chat for that older report. I had to dive deep into the internet to find it, but we did get it. But also in 2001, 20 years later, they did another in-depth study on special minimum or subminimum wage program. In 2021, factors influencing transition, as well as this year about how the U.S. Department of Labor, or DOL, could do more to ensure timely oversight. And I apologize that I have an oversight on the spelling of oversight, but wanted to flag that. But the overall idea here is that if you're looking for some very detailed and interesting reports on how the 14C program is being implemented, some critiques of it, and factors including transition, please look at those reports. They're extremely well done, and they're very important resources. Let's go to the next slide. One of the most interesting things that we learned during this report is to look at the number of employers and employees served under the 14C certificate program. So remember, this program has been around since 1938, 1940, somewhere around there. And of course, it started small. But as we get to 1979 or so, we have nearly 4,000 employers using 14C certificates. And with those nearly 4,000 certificates, there were about 175,000 employees with disabilities that were paid a subminimum wage. And as you can see on the screen, that number increased dramatically between 1979 and 2001. And in 2001, there were over 5,500 employer certificates and over 424,000 employees. And it should be noted that employers have a large range of employees that are paid subminimum wage under each particular certificate. So, for example, you could have one employer that only hires one person with a disability under 14C. However, you can also have one employer hiring 200 or 300 or 400 employees with disabilities. Now, when we get to 2019, there's been a considerable drop. And you can see that instead of being at over 5,500, there's now in 2019, just over 1,500 employer certificates that serve just around 120,000 employees. And so it is very startling in some ways to look at that decrease in 19 years. As we get to today, the slide says 954, but I just checked that website in preparation for this presentation, and as of June of 2023, there are only 919 employer certificates out there. And so you can see a steady and definitive drop since 2000. And there are many different factors for that. And it's also important to point out that the number of employees has plummeted quite considerably as well. We include there that there's between 40 and 50,000 employees that are served, and that's only because under the US DOL information that is available, only the number of employees where there are active certificates are counted. So we can pretty clearly determine that there's at least 40,000, but for those employers that have active pending certificates, we estimate there's another 10,000. But whatever the number is, you can see it has dropped considerably from that pretty high peak in 2001. I will put in the chat now that list of certificate holders, so you could check out that list yourself, and you can look into the number of certificate holders by the type of organization, CRP or school work experience program, or whatever you want, by state, by number of employees, to get a sense. And I'll also point out that it's very interesting that if you look at the state by state, there are some states that use 14C a whole lot more. So for example, in Minnesota, my home state, there's around 4,000 to 5,000 employees with that are paid a subminimum wage. And that's quite a big number of that 40 to 50,000 total. Let's go to the next slide, please. We have about 5 to 7 minutes left, so we're going to go through these challenges in the remainder of the slides relatively quickly. We wanted to point out that over the history of time, the program, the 14C program, has had many examples of low wages and little advancement. So between, for example, 1994 and 2003, the average wage for people with disabilities receiving a subminimum wage has varied between $2.64 to $3.34. And there may be reasons for any particular individual to have such a low wage based on productivity, for example. But our concern is that the 14C program was also meant as a training program. And there's been many, many studies and a lot of examples of how people's wages who are in the 14C program remain at that low level. So it doesn't seem to advance wages, doesn't seem to train people with disabilities more skills. Similarly, there has been abuse and financial exploitation in the 14C certificate holders. One of the main examples is in Henry's Turkey Farm in Iowa, and that's a little town called Advocacy, where a number of men were paid as little as 41 cents per hour, and there was a legal case about that, and there was determinations that there was a hostile work environment created by the employer, as well as over $1 million owed in back pay to individuals with disabilities. There are other examples of abuse or neglect, but that's one of the primary ones. Finally, as we get to the bottom of the slide, we'll look at how the US DOL has determined that in about 65% of their investigations, there have been violations found. And so if you've got a program failure rate of over 65%, that says a lot about the program. US DOL, the US Department of Labor, also found that there's nearly $15 million of back pay owed to individuals with disabilities. So there are significant problems with non-compliance in that program. Cheryl can say a few words about the connection between disability and poverty, and then we'll go on to the next slide.
Dan, I just want to say that it's well known that people with disabilities are among the poorest in the country, and a person with a disability is twice as likely to live in poverty as their non-disabled peers. So poverty is not the American dream for people with or without disabilities, and the only route out of poverty is through work. So I think it's really important to recognize that if we want to improve the economic likelihood or the economic situation for people with disabilities, we have to offer them the same opportunities for employment that are offered to everybody else seeking a job. Real jobs, real wages. Back to you.
Thanks, Cheryl. And as you might expect, that because of these problems and implementation issues and abuses, quite frankly, there have been many calls to phase out or eliminate the 14C program. This Hallmark report in 2020, which I just put a link in the chat, discusses both the pros and the cons, and I encourage people to really look at it because it really does do an amazing job of understanding and exploring what the arguments are on both sides and how interrelated there are. But I'll also note that the U.S. Commission on Civil Rights recommended a clear phase out and elimination of the 14C program. We'll go to the next slide. And even though that there has been attempts at the federal level to eliminate 14C, there have been many state actions to reduce or eliminate. We've listed some different ways that states have done this. Through defunding, listed the states there, Vermont, District of Columbia, Wyoming, legal actions, in particular by the U.S. Department of Justice in Rhode Island and Oregon, executive orders, for example, in Illinois. And we'll go to the next slide. But by far the most common type of approach by the states has been to act through legislation to eliminate, phase out, limit 14C programs. And I've listed a chronology of the different states. It is a good idea if you're interested in thinking about state legislation in your own states that have not banned 14C to look at the different approaches. But a lot of these look at phase out plans, data collection, data reporting, looking at individualized outcomes to ensure that people with disabilities are getting the services that they need and are getting the benefits, as well as moving towards competitive integrated employment. I do have an asterisk there by Minnesota. Minnesota's legislation was a study to phase out. There was also a bill to eliminate, but that bill did not pass in the most recent legislative session. Let's go to the next slide. We also wanted to point out that there's been a long history of federal legislation. We'll just explore a few more recent attempts at federal legislation to limit or eliminate 14C programs. All these bills are critical and represent different approaches. The last few of them, the transition to competitive integrated employment, as well as the first one, those were not passed. The TCIEA, Transformation to Competitive Integrated Employment Act, was recently introduced this legislative session. Let's go to the next slide. We want to recognize also that federal agencies have acted in this area within the bounds of legislation. The U.S. Department of Labor Wage and Hour Division has issued program bulletins, talked about the CMS rule, the Government Accountability Office as well, the EEOC, the Equal Employment Opportunities Rule, and the USDOL rule are different measures to promote people with disability being hired in employment and competitive integrated employment. But also the federal government agencies have awarded grants, taken on initiatives, and conducted research that support the move of people with disabilities to competitive integrated employment. We'll go to the next slide here. We want to also recognize that there are a lot of changing times. We're still coming out of the COVID-19 pandemic and its recovery. Artificial intelligence can be used for good to promote competitive integrated employment, or it could be used for evil to take discriminatory actions against people with disabilities. But there are certainly new work dynamics with many people working from home. There still remain employment gaps, particularly people with disabilities have a huge gap of employment in comparison to people without disabilities. And if you are Black or Latinx or other races, and you have a disability, there's more of a gap. There's also the larger societal context where the politics are more divided, and sometimes in some ways society has gotten more difficult for people with disabilities, but there's also an undercurrent of hope and a recognition that people with disabilities are more accepted and have more expectations about what they can do in society. And this gives us a lot of opportunities. And we'll go to the next slide and wrap up to get to your questions. We want to point out that there are two main types of strategies and recommendations. One is where there is a ban or a phase out or non-use in your state. And please look to a number of different states that have already gone this route. You can look at phase out plans, tracking of wages, unemployment statistics, individual outcomes, employer transformation, communication, messaging, and having high expectations for people with disabilities, as Marlena and others have mentioned earlier today. And we also need, as a society, to address important questions around the safety of individuals with disabilities and their access to health and services benefits. The other avenue is where there is not a ban or a phase out. Of course, consider future bans, phase outs, executive orders, or defunding, but there are things that can be done even when there is not a ban at the state or local level. Employment first, discovery, customized employment, assistive technology can all be utilized for people with disabilities with or without a ban. State agencies can become more coordinated and to have more funding for competitive integrated employment, and schools can work to heighten expectations, coordinate with vocational rehab, and have robust transition programs. Of course, there needs to be a refocus on competitive integrated employment as times change, so do strategies. With that, I want to turn it over to Cheryl or to Amy for any last words, but I really thank DETAC for this opportunity and appreciate your attendance and your time. Thank you.
I have nothing to add at this point. I'm busy answering questions in the chat box. Thank you.
Thank you very much for that amazing presentation about the contents of the reports, including some recommendations for a well-phased 14C phase out. Chairnet is putting the link to the report in the chat. We understand that some of you have been unable to access the links, and guess what? All of those links that Dan referenced in his wonderful presentation are in that report, so check it out. Let's open up now. Let's move forward to the question and answer session. We have a slew of questions, but the first one I would like to address is an individual by the name of Harris Caps. Thank you so much for your questions and your comments. But I'd like to be clear in stating that when we talk about people with disabilities in competitive integrated employment, we are referring to any person, regardless of the significance of disability. We believe in person-centered planning and that every individual is capable of achieving employment in the community with the proper supports and services. So I want to clarify that because we may have a little confusion in the comments about that. So Cheryl and Dan, my first question to you is, let's talk about choice. As we can see in some of the comments, people are really saying that people with disabilities in these sheltered workshops don't have a choice. So let's talk about choice in this process and how we support a person with a disability to have that voice and a choice and getting out of the shop and getting employment. Who wants to go
ahead, Cheryl?
Okay, well, first of all, we know that there has been in place for a long time the school to sheltered workshop pipeline. Even though we started educating people in free and appropriate public education back in 1975, there was really not an expectation that those individuals were going to go anywhere other than the sheltered workshop. So their choice was you go to the sheltered workshop or you go home. And many people have been there for 20, 30, 40 years. This is a life that they've come to know and that they are more or less comfortable with. So that's why the pre-employment transition services and actually providing people opportunities to know what kinds of jobs exist in the U.S. economy, what kind of vocations are available and presenting people with options so that they can actually experience and make a choice. Because if your choice is go to the sheltered workshop or go home, that's not a choice. A choice requires multiple choice, and that requires information and respecting the individual's expression of what they would like to do when they grow up or what they would like to be. And we need to start asking kids about that in kindergarten, not waiting until their senior year of high school to decide, okay, let's talk about work.
I'll also add to Cheryl that we're talking about expectations and we're talking about informed choice. And when we're talking about expectations, let's have a society where we treat people equally. When we think about raising our kids, we talk about over dinner, over lunch, about what do you want to do with your life? What kind of work do you want to do? Why is that any different than people with disabilities? Let's have the same expectation, but it also have to be paired with opportunities and informed choice. And I've been around this long enough to know that sometimes, as Cheryl just mentioned, that sometimes there's only one choice, and how much of an informed choice, that's not much. But when we really get into the methods that we're talking about, customized employment, discovery, job exploration, that's what we're doing. We're setting choices and we're making them informed choices, and we can help to ensure that society works to the benefit of everyone, not just a part of that population.
Thank you, Cheryl and Dan. I have been scrolling through the list of many questions that we have, and I appreciate the clarity around choice and things of that nature. So we have some questions around funding and maybe sharing some ideas around how states can get creative in not funding these types of services, either at the state level or at the federal level. So are there any suggestions in that area for how states or even our partners at the federal government can maybe calculate a well-phased approach to integrated employment versus 14C kind of sheltered work? Turn it over to you, NDRN.
I'll start and Cheryl can jump in. And, back in 2001, VR vocational rehab has that rule that there are pretty strong limits on funding sheltered workshops and not counting it as a employment outcome. So a lot of those rules are there. We've talked about the CMS rule, but we've seen states and the federal government fund different initiatives that support competitive integrated employment. And there are even private foundations that do the same. And so there are many ways that the government can coordinate its efforts, its funding, its approaches through rules, through legislation, but also through its grant making and its funding decisions. And those funding decisions can come from Department of Labor and Industry, whatever your state has, through a Department of Education, or even through different types of work incentive programs that might be done through a human service agency. But it takes that coordination, it takes that vision, and I'll also say it takes that compliance with Olmstead, because remember, Olmstead applies broadly and applies to multi-governmental entities. And so if you have a coordinated approach, then the state becomes a vehicle for ensuring that it's complying with Olmstead, as well as supporting individuals to get to competitive integrated employment. Cheryl?
I think I'll approach that from a slightly different perspective. I think that we hold people with disabilities to a higher standard than we hold people without disabilities, particularly youth. Youth with disabilities have to demonstrate that they are ready for work. What the heck does ready for work mean? When I turned 16, my parents never said you're ready for work. They said, you want a car, you better pay for insurance and be able to buy gas. So I went out and I got a job and I hated it. I left after 4 days. So my parents didn't then come back and say, well, you're not capable of working because you didn't like this job. We have to recognize that people with disabilities are capable of working. We have to stop spending money on them so that they can demonstrate that they can work. And we need to stop supporting any services that take away that option of applying for and obtaining jobs in the community. And things like the state of Missouri, where the Department of Education funds segregated services, I personally think that that's discriminatory, and there needs to be a class action lawsuit in the state to end that practice, because until they're legally challenged and financially penalized, they will continue to do it.
Thank you. So we have a great question about data and where folks who transitioned out of the 14C programs are. Are they working in the community? So Cheryl and Dan, is there any insight that you can provide for where folks with disabilities go? Where these people go once states phase out that 14C model?
So I'll first start, then Cheryl can chime in, but we do have a great number of states and a growing number of states. So for example, as early as 2002 in Vermont, there are studies on how people have went not to a parent's basement, but to competitive integrated employment. And we have examples more recently in Oregon, as well as Maryland and other states that have been in the vanguard on this. And there are a number of resources in the report, particularly from some DETAC publications that talk about system transformation. And this has been done before, and it's nothing new. And there are a full variety of different options that support the transformation, and those are included in the recommendations, but they involve focus on competitive integrated employment as an expectation as a primary starting point, and then adapting state models of employment as well as funding to ensure that those efforts are focused on competitive integrated employment. So I'll have that as a teaser for the report. Check that out, as well as some of the links in there. But this is not the first time it's been done. There are states that have already done this, and they're successful at it.
All right, next question. Oh, go ahead, Cheryl. I'm sorry. Go ahead.
Go ahead, because I really don't have anything to add to that.
Okay, so we have a question which we know is a barrier in the field. The myth, the confusion about working in an integrated job and keeping benefits. So what type of strategies or suggestions do you folks have for our audience today, for those folks, for those people who really want a job but are worried about how that's going to impact their benefits, which is just such an important question?
I'll take this one, Dan.
Yep.
Yes. Well, the Social Security Administration and the Social Security programs do have work incentives, and work incentives work. If people understand how to utilize the work incentives, there is a way that they can work their way off of benefits without it being detrimental to their bottom line, their financial pocketbook. And of course, there are two different kinds of Social Security benefit. The one I love to show to people is the supplemental security income, because that program favors work. And basically, for every $2 that the individual earns, their benefit would only be reduced by $1 after a general income exclusion. So you can show people in black and white at the end of the month that they're going to be financially better off working than not working. Social Security disability insurance is a little bit more complicated, but I still insist that work incentives work. And if people understand how to use the work incentives, how to identify the work incentives, that they can return to work without being worse off than they are not working. And so I think that's kind of something that people have to trust, and then they have to get the benefits counseling and the information they need to decide for themselves if work is a better opportunity.
And please connect with your local centers for independent living, your VR agencies who can share resources and connect you with the benefits counselors. I'm sorry, Dan, I cut you off. Go ahead.
No, I'm sorry to interrupt, Amy. I wanted to point out, and I just put this in the chat, that there are often state programs that bridge the gap, so to speak, between people who are making that transition. So, for example, in Minnesota, just posted a link in the chat about medical assistance, which is the term of art for Medicaid in Minnesota, for employment for people with disabilities. And really what that does is to supplement the work incentive programs that Cheryl was talking about by providing a state benefit to ease that transition and to really get people more money while retaining benefits to the extent where they can make a more easy transition to being fully off of benefits and to becoming getting health insurance benefits from a private employer, for example, or a state employer. So there are different ways in different states. People have solved this problem before. It's a very common and important one, but there are some tried and true methods to address that very important concern.
We are running out of time. We have so many more questions. We'll give you one more, NDRN, and that is from David. Good to see you, David, on the webinar. Can the speakers comment on the AbilityOne's program decision to phase out the 14C certificates throughout the program as another example of some positive progress on the issue?
Thank you. We did not prompt David with that question, but I'll turn it over to Cheryl for this one.
NDRN is fully supportive of that decision. That was a program, again, that goes back to the mid-1930s when it was first operational. And the purpose of that was to employ individuals and give them, again, the dignity of work. So there's no point in trying to dignify employment if you're going to limit people's ability to earn. And so we are fully supportive of that. We think that the moves that they're making will be significant in that segregation is no longer the lifelong goal of these problems, of these programs. Individuals will be able to obtain some skills and some training and some work history, but then they'll be able to take those skills with them to a real job in the community with real pay and real opportunities for integration with peers that are not disabled. And again, normal people do not go to segregated settings. So we want everyone to have the opportunity for that choice.
All right, Chairman, please save the questions that we have in the chat because we will definitely need to send a sort of follow-up in response to the slew of questions that we have. Let's move on to DETAC updates briefly. Next slide, please. So we are pleased to announce that we have a webinar coming in July that is focused about artificial intelligence in the workplace. What does that look like for people with disabilities? What type of tools and resources are at our disposal to help somebody in their job with regard to utilizing AI? So please join us along with our partners at ODAP's Partnership on Employment and Accessible Technology. Register at the link below. Next slide, please. We've got two really exciting opportunities for grantees, two new e-learning communities. Howdy Partners, maximizing employment for people with brain injury through collaboration, is open to all grantees and focuses on guiding participants to understand the structure of other systems, how to develop partnerships, to leverage funding, and how to partner with other grantees. So space is limited. Please click on that link to register. The other e-learning community we have available is You Can't Build Community Without IL. With our partners at April, this is specifically for Centers for Independent Living who want to focus on skill building, peer support, resource sharing, and community outreach. We have two cohorts, one for employment SILs that really need more resources and troubleshooting challenges, and one for non-employment SILs who are eager to start stepping up the game in employment, but aren't sure where to start. So please click on that link to apply. Registration is limited, space is limited. Next slide, please. We'd also like to friendly remind you that the DETAC provides free technical assistance. If you need any assistance or are curious to know what type of help we can give you, please click on that link to reach out and we'd be happy to schedule an initial call to set up that TA for you. And we'd also like to remind you that we have additional products that were referenced during today's webinar. All you have to do is click on that link to access those products. And a final thank you to all of the team at the National Disability Rights Network. I was thinking about our journey with this project and that Cheryl and I had this discussion last summer. We talked about drafting the report last summer, and I just want to take the time to acknowledge the team's efforts. There's so much going on. You just had a stellar national conference, but they delivered, they gave us a quality report, and we are just so excited to be able to share that and to partner with NDRN. So thank you to Dan Stewart. Thank you to Cheryl Bates-Harris and everyone today on this webinar. We hope you have a wonderful, great rest of the afternoon, and we look forward to staying engaged with you. Bye now.